Welcome back, episode 19 of Making Sense of Your Money. Today I'm going to be speaking with Lucy Berkman, Special Counsel with Phillips Lytle, and she has a focus on trust and estate planning. Very excited to have you here today, Lucy. Thank you so much.
Thanks for having me, Elizabeth. Pleasure.
So, how we know Lucy is I've actually worked with Lucy both on a personal basis, and we've worked with her with clients probably for the last, 6-7 years.
I would say so.
And it's been a really great relationship, a great asset for us to have because of our niche and the types of clients that we work with, right? As many of you know, our main clients are that kind of retirement red zone, people really focusing on income distribution. And a big part of our job is trying to figure out how to make sure that you don't run out of money. And that conversation usually sometimes spirals into, okay, well, if I'm not going to run out of money, what's going to happen with this money? How do I protect this money? And a big question that generally comes up is focusing around trust. It's a word I think that's thrown out a lot out there. A lot of people are unsure. Is that for me? Should I own a trust? Because I have a friend who owns a trust. What even is a trust? So let's start there. Super softball to you, Lucy. If you could just start with what is a trust, how do they work, and then we'll get into kind of some of the nitty gritty after that.
Sure, yeah. So you mentioned, your client comes in and they say, well, my friend has a trust, so I need a trust. Well, maybe that's not for you. So what is a trust? Generally it is, we can consider it to be this entity or vehicle that is set up to manage your assets. I like to consider it and compare it to kind of like a business entity where you have these operating documents in place that created that business, and the same thing happens when we start to create a trust too. So you end up having a trust agreement that is set into place and it dictates what assets are being managed, who manages it, and who benefits from that, the trust agreement and the trust itself. The players are the grantor, that's the person who is creating this trust in the first instance. You've got the beneficiary, that's the person who is reaping the benefits from that trust over the course of the trust lifetime. And then of course, who's going to manage those assets within the trust, and that is your trustee. Beyond the real basics, we've got differences in the types of trusts that we can create too. Basically, we've got something called a revocable or an irrevocable trust. Revocable meaning basically during your lifetime, you have access to everything in there. You can amend the trust agreement. You can take those trust assets out there. So you create the trust, and 2 months down the road, you say, geez, what the heck did I do that for? I don't want this anymore. You can dissolve that trust and take all your assets out. On the other hand, if you got an irrevocable trust out there, I basically tell my clients, geez, once it's in there, it's really hard to get your stuff out of there again, and it's super hard to make amendments. Not saying that it isn't possible, because it is possible, but it might be tough. Another two key differences to think about are inter vivos versus testamentary trusts. Right, so inter vivos trusts are trusts that we create while we're still living during our lifetime versus testamentary trusts, which are created and operate as part of our last will and testament. And it does not take effect until after we pass away, if at all, depending on how your will is written.
Thank you. It's a lot of jargon,
Yeah,
in your industry.
yeah.
And I think what's so great about working with you is you really do have just an easy way of speaking to people. Anytime, that I've introduced a client, I think one of the first things I say is, she's, yes, an estate attorney, but she talks like a real person.
Oh, good.
So,
That's good to hear.
so we appreciate that so much. So thank you. So that kind of lays the groundwork. Now it's again, kind of going back to that question of, my friend Joe has one, should I have one, right? Who are they right for? And at what stage in your life should we be looking at it? Are there different trusts for the different stages? Maybe we can start with kind of where our niche is, which is that retirement red zone, or people drawing an income in their retirement. Who in that category are trusts really good for?
Right. So it all depends. It is certainly a case-by-case basis, right? So in this retirement red zone that we're talking about, a lot of times the primary goal of someone in that older generation is they come in and they say, I don't want to go through a probate proceeding. I don't want to go through court. I don't want my kids to have to go through court with my assets once I pass away. How can I avoid that? The trust actually is a good vehicle for doing that, and sometimes that's really the primary purpose of it, right? So we have our assets being thrown into this trust vehicle. We dictate what's happening to that. You as the grantor end up being the primary beneficiary generally during the lifetime of the trust. Maybe that trust then terminates upon your death, and then the trust agreement itself operates kind of like a quasi-will for you. Because within the trust agreement, you as the grantor are going to say to the trustee, hey, this is where my assets are going to go when I die, right? And the beauty with that is it doesn't pass through the court system. So unless people and your beneficiaries are arguing over something,
Sure.
So there's no guarantee for it. But for the most part, this court does not have to pass on that. Unlike a last will and testament, before anyone can operate with that document itself, this court has to give its stamp of approval, not so much with the trust. So it's a good tool to avoid a probate proceeding, okay? Beyond that, we're thinking about, well, geez, who are my beneficiaries? If my beneficiaries are my kids, maybe I have a kid out there who is disabled, and I want to provide for them under a trust agreement or under my will, a testamentary trust. We can set up certain trusts that allow for your disabled beneficiary to still reap the benefit of different government benefits that they have out there, and not run afoul of that by having too much money, basically. Other times we have kids that, geez, maybe if they're going to get $100,000 in their hands, we don't want that to happen so much because they tend to spend it right away. So it's a way that we might be able to kind of control from the grave a little bit and dictate when that child might be able to get their hands on certain assets. With a trust, whether it's that inter vivos or the testamentary trust, you also dictate when the beneficiary, like I just said, when the beneficiary is able to get their hands on the assets. So sometimes we see what I call staggered or stepped payout provisions in the trust agreement or the trust document itself. So for instance, let's say again, I'll use $100,000, okay? My heir is going to get $100,000. They're, 25 when I pass away. I really don't like that they're going to get $100,000. So I'm going to say, well, maybe they'll get half of it at 25, another half at 30, okay, for example.
They might be a little bit more mature, make some better decisions.
Exactly,
Sure.
exactly. So a lot of flexibility in terms of when you can have these payouts and when you want the trust to terminate. So those are two specific examples. Also, sometimes we're talking about Medicaid planning, right? So we're up there in age, we're in this retirement phase, and now we're thinking about, geez, do I want to start considering preservation of assets in case I need nursing home care? How am I going to pay for that new nursing home care? And sometimes what we will do, especially with homes, your primary residence, we will set up a specific type of Medicaid asset protection trust. There's kind of what I call magic language that goes in there to protect the home. But you dump your home into that trust, and then it preserves it for your heirs, and it takes it out of the available resource pool that you otherwise might have and be required to draw down off of to pay for the nursing home care.
Right.
So, specifically, again, when we're talking about retirement age, and the older generation, Medicaid planning, and usually it's an avoidance of probate that we're looking at, combined with, geez, I want to control when my heirs are getting their money, ultimately.
All right.
Okay.
Yeah, if I could jump back, because you did mention something that I think we get a lot of questions on, which is that primary residence question. A lot of times clients will come to us and say, should I be signing this over to my kids? That's I feel like most people, that's step one, right? They've heard, just get out of my name, get into my kids' names. But there's pitfalls with that.
There are.
So can you expand on that a little bit?
A little bit, yeah. I mean, we could have a whole podcast
I'm sure.
on that in and of itself. So when we're talking about Medicaid planning and preserving that primary residence, it is usually because we want the primary residence, the funds, the equity that is built up in that house to go up and pass out to our kids, our beneficiaries. So how do we do that? Because otherwise we would be in a position where if we need the nursing home care, that's not a good thing to have that house in your own name. It ends up having a lien against it by the state, or you're selling it to get the funds in to pay for that nursing home care. So one of two different routes. One is what you mentioned, where we have the deed out to the children. You retain what's called a life interest in that. So you live there for the rest of your life. You still maintain the property, you're paying the real property taxes. If something happens in terms of maintenance, you still pay for it. So if the roof goes, you have to replace that, it's on your shoulders still. Your kids can't ever kick you out.
Okay, because I think that's people's main concern is, what happens if my kids get divorced, or can their, ex and then be claw into this or anything like that?
Yeah, well, I think that's another side venue on that side conversation. But at any rate, so your kids can't kick you out, so you're there, you are living there. Pros and cons with that, and I always warn people, I think the biggest downfall with that is if you ever want to sell that house, and let's say you want to downsize, then it becomes an issue of needing all the kids to sign off on that sale with you. There's a technical split in the proceeds, the sale proceeds. There might be a capital gains issue that you otherwise wouldn't have.
Sure.
So there's a little bit of downfall to that. The pro with something like that is because it's going to be automatically in your kid's name. So you actually have a deed out from, let's say me to you as my child, right, with this reserve life estate. Once I pass away, it automatically vests with you, and it doesn't have to go through the surrogate's court, okay? So you're avoiding a probate proceeding with respect to that asset as well. The other route you can take is an irrevocable trust that's set up specifically for Medicaid protection purposes. One of the downfalls with that is if you sell the house, the proceeds have to get dumped back into that trust. And for purposes of Medicaid protection, you can't touch the principal. So if the money's sitting there, let's say it's $200,000 in that sale proceeds, the money's sitting, you can't just go in and say, oh, I'm going to take a trip around the world now.
Right.
With those funds. No,
Gotcha.
they have to sit there. So that's kind of it in a nutshell.
Okay.
I think we could definitely have a whole podcast on Medicaid planning.
An episode in the future,
Yes,
for
exactly.
sure. I love it.
Yeah. And one other thing too I want to mention with respect to, again, if we're talking about an older generation and we're thinking about trusts and where they come into play, estate tax planning purposes. So, we, as an estate planner, I'm looking at, what could you possibly have in terms of asset value at the time that you pass away? Are we looking at an estate tax scenario? Is it possible? Of course, we never know what's going to be going on, especially in the next couple of years with sunsetting and whatnot. But there are ways where you can incorporate, especially within your will, certain provisions to create different types of trusts that can save you on estate taxes at the end of the day and operate to either minimize or get rid of them in full. So if you are not aware of that, then, and it's not written into your will or another trust document, an inter vivos trust document that you have, you can't utilize that stuff.
Sure.
So it's really important to have the conversation, to be honest with you.
Yeah, okay, so great. So we've got what are trusts. We talked about, kind of that generation who's maybe using their income that they saved and is looking at how to pass that on. But what about that younger generation, right? Like myself, yourself, right? We're young, we've got families. Like, if and when do trusts maybe make sense for people in that situation?
Great question. And even if you're younger like us with little kids at home, I think it's very important that you start considering the trust situation. Maybe not so much to do an inter vivos trust right now, but I think of utmost concern is the testamentary trust. So getting a will in place, that creates trusts for the minor children under the will, in the event that maybe the spouse also passes away, with you, say it's a tragic car accident, and the reason being is because with our asset pool that we have, which would include life insurance, retirement assets, things like that,
It can definitely add up.
Yeah,
Right.
it adds up, and we have to think about, if my child is the beneficiary, how are they getting those funds, right? So I'll use myself as an example. I have a 7-year-old, okay? And I don't think I want her to have the benefits of my life insurance policy outright. You're talking hundreds of thousands of dollars, right? Well, she's also a minor. We can't do that by law, right? We can't give her, 300 grand or something, right? So what happens with that, right? If I don't have a proper trust set up under my will, it ends up in a legal guardianship type situation that is joint with our local surrogates court, okay? Which is good. I mean, there's a check and balance there. Your legal guardian can't just go in and dip in and take money out to spend on the child. He or she does have to ask permission of the court, which can say yes or no. But my biggest concern with all of that is that the legal guardianship by law ends at age 18. It can go out to age 21, but only upon consent of the 18-year-old. So I don't know any 18-year-old that's going to say, yeah, go ahead and have, have control over me, for a couple more years. So, you could be in a situation where you've got an 18-year-old now getting their hands on hundreds of thousands of dollars. You can avoid that by setting your will up properly to include testamentary trusts in there, and that goes back to that stepped situation where you can have these stepped payouts, okay?
Right.
So, I'm not going to have my 18-year-old get $100,000, certainly, but, maybe when they are 25, they'll get the half, and then 30, they get the rest of that, okay? Mm-hmm. So it's really important, I think, even when you're younger, especially if you have children out there that are minors, to consider, what do I have? What could go into their hands? Am I comfortable with having that guardianship situation arise? Mm-hmm. And if not, then you need to get the will in place at a minimum with the testamentary trust provisions.
Love it. Great.
Yeah.
Hope everyone's taking lots of notes. It's all really great stuff. The other group of clients that we do run into at times are people who maybe have children with disabilities, or maybe even have a sibling with a disability that they're now the caretaker of, but that they'd want to make sure was taken care of after they pass. How does that work? Where do trusts come into play with that?
Yeah, that's a great topic to talk about too. So there's different types of trusts that can be created. Again, I mentioned it in the very beginning, creating trusts, especially under your last will and testament, that provide for disabled children. So you can do that while you're living too. And there's really two types of trusts that would operate. So let's say, for example, I am under a disability, I'm getting government benefits. I come into a settlement, I was in a motor vehicle accident, okay? And what I can do is create a specific type of trust. It's called a first party supplemental needs trust, where I dump those settlement proceeds into that trust. The whole purpose is to supplement what I'm getting from government benefits versus supplanting those. So generally what it comes down to 99% of the time is, okay, I need a new television, I need furniture, I need a new car, I need to pay insurance, things of that nature come into play. Yeah, life costs, entertainment even comes into play with that. But I still maintain my government benefits that I'm getting, and still can dip into that specific trust, and it doesn't nuts up the government benefits. Okay. And it's usually, those things come into play when it's what we call means tested, which means you can only have a certain amount of resources or assets under your name. And if you go over that, then it causes problems with the type of government benefits you're getting, and you could be dumped off of that for a little bit of time. So that avoids that. But under the same type of auspice, I guess, is the third-party supplemental needs trust, which can be created by somebody other than the person getting the government benefit. So it would be me creating it, let's say, for my child who's under a disability.
Okay.
Does the same thing, operates the same way.
Okay.
You can do it inter vivos, or you can do it testamentary as well. So those are kind of the two types of trusts that we're looking at generally creating when we're dealing with somebody with a disability.
Right, because if that person is named just as an outright beneficiary,
it might cause them problems.
Sure.
Yeah, and the thing, what happens too is once you reach a certain age, which is 65, okay, if you inherit before then, Not really that big of a deal because you can always create that supplemental needs trust for yourself, but as soon as you hit the
As
age
that
of
first
35,
party supplemental, you're saying?
right,
Okay.
right. But once you hit the age of 35,
Oh, 35,
you can't,
okay.
or I'm sorry, 65,
Okay.
65, you can't do that anymore. And then you're forced into different types of vehicles. So really, that's kind of when it comes into play.
Okay,
The
yeah, no, that's
65
great. That's
years,
great
yeah.
to know. So,
Yeah.
so for those individuals, you know, who maybe have children in that situation, without knowing obviously when they're going to pass, that's why
Right.
these make sense to set up ahead of time.
Exactly. Yeah,
Okay.
yeah.
Great. So a lot of good stuff. Are there downfalls? Are there like, why wouldn't somebody do one? What are some of the downfalls that you see with trust?
I think the main thing is cost. A lot of people find it to be cost prohibitive. You know, coming in to see someone like me, it can be costly at times to do trust creation. You know, but at the end of the day, you know, especially if you're looking at trying to avoid a probate proceeding, you know, you got to weigh your cost versus your benefit there. One, two, it's a lot of legwork sometimes on the grantor, right? Because the grantor is the one that is creating the trust and funding that trust. We've got to fund the trust. So we have to make sure our stuff gets into the trust. Right, so for example, if we've got a bank account out there, it's titled in my name alone, I need to retitle that into the name of myself as the trustee. So the trust is actually holding that bank account. Otherwise, I pass away, and guess what? That bank account is going to be considered part of my overall estate. It never made it into the trust.
Right.
So
you had the document, but you didn't do the actual work.
I didn't do the actual work. So so there's a lot of legwork and follow-up that the grantor has to do. It's not anything I, as the attorney, I can help you a little bit along the way, but really it's on the grantor's shoulder.
Okay.
To do that. There's also monitoring, right? There's consistent monitoring for this. So, for example, if you start buying a new house, you buy a vacation house, you want to make sure it's dumped into that trust. Right? You want to make sure all your new assets coming in are dumped into that trust because, again, at the end of the day, you don't want to have these straggler assets out there that result in having to go through an estate proceeding through the court system, right? Because if the whole goal, or one of the goals, was to avoid that, now all of a sudden you're back at square one. Right? And one more thing, too, because I mentioned vacation home, right? That's a big thing, too. And one of the reasons why people at any age might be considering a trust is to dump their vacation home that might be out of state into a trust that we create here. And the reason being is, and I'll use Florida as an example only because it comes up all the time.
Yeah, we've got tons of snowbirds. So.
Right. So we've got these snowbirds that are buying their condos, their apartments, their homes down in Florida. Then they pass away up here and they're still a resident of the state of New York. Well, we're opening the estate, in the state of New York. Your executor then has to go down to Florida and open up another estate proceeding down there in order to take care of that house. So to avoid that, we can dump it into the trust and therefore avoid that secondary estate proceeding down there. And sometimes that's the only thing that's in the trust too.
Sure.
The second home. So monitoring is very important throughout the life of the trust. And then also we have to be cognizant of tax reporting requirements as well, because it might be different depending on what type of trust you are creating. Sometimes if we're just doing a kind of a standard grantor revocable trust, you're going to be reporting all of your income just under your general Social Security number, just as you normally would if you didn't have that trust out there. But once we branch beyond that type of trust, then there's different reporting requirements, different tax returns that have to be filed too.
Okay.
So a lot to think about.
It is. No, and I mean, you mentioned the cost, is kind of the first one, but people bring that up to us too, right? That that's one of the questions they ask us is, should we get a trust? And, oh gosh, but is it going to be super expensive? But, we have a very honest conversation with them of like, hey, it's not my job to tell you whether you need a trust, but if you did, and it costed you, X amount of money to protect X amount of money, like, does that make sense? I mean, and that's, I think just having that kind of like bird's eye view, it's tough maybe when you're in the situation, to scratch out a check, but to really have that bird's eye view of like, if this just went on, and I didn't have a plan, what would be that end result of the cost, right?
Right,
And I think
exactly.
that's, a good way to kind of look at it. So, yeah, this was great, Lucy. I really appreciate your time. We're going to put up Lucy's information so that you have it. Feel free to reach out to her if you have any questions. As I mentioned before, she's fantastic. She's very easy to talk to, as you can see. She somehow put a ton of jargon that we talked about today in simple terms, so we do appreciate it. As always, feel free to continue to check out our YouTube videos. We put these out obviously regularly with different topics. And as always,
Go Bill.